Good morning, ladies and gentlemen. The case that will be present today before this honorable court is the case of Anglo-Norwegian Fisheries Zone case. The senior counsel on behalf of the applicant may start first. The court may proceed now.
Good morning, my lady. May it please this honorable court, my name is NURAFRINA SAFIAH, appearing as the counsel on behalf of the applicant, the United Kingdom of Great Britain and Northern Ireland. Appearing together with me today is my learned co-counsel, Mr. Ahmad Iqbal Ihsan. On behalf of the respondent, we have the learned counsel, Ms. ZAHRATUL HANAN, and he will be assisted by his co-counsel, Mr. ALIF AMMAR. My lady, before I proceed, may the facts of the case be of assistance to this honorable court?
Yes, please.
Much obliged. The historical facts laid before the court established that as the result of complainants from Denmark and Norway, as there was British fishing vessels appeared off the coast and the local population became perturbed. This issue grew bigger and the Norwegian government had specified the limits within which fishing was prohibited to foreigners. However, in 1932, British trawlers extending the range of their activities appeared in the sectors of the Norwegian coast west of the North Cape, and the number of warnings and arrests increased. On July 1935, a Norwegian royal decree was enacted delimiting the Norwegian fisheries zone north 6628 north latitude. However, the United Kingdom questioned the delimitation. Incidents then became more and more frequent, and a considerable number of British trawlers were arrested and condemned. It was then that the United Kingdom government instituted the present proceeding. My lady, therefore, I shall now proceed with my submission. The issue to be submitted before this honourable court is whether the lines prescribed by the Royal Decree 1935 as the baselines for the delimitation of the fisheries zone of Norway have or have not been drawn in accordance with the applicable rules of international law. My lady, I will be submitting on the general principle concerning the issue, and my co-counsel will be submitting on the suggestion for methods of delimitation of the fisheries zone that are consistent with international law. If there is no further question, may I proceed with the first issue, my lady?
Yes.
Much obliged. On the issue that is brought to this court, we submit that the lines prescribed by the Royal Decree 1935 as the baselines for the delimitation of the fisheries zone have not been drawn in accordance with the applicable rules of international law. A Norwegian Royal Decree 1935 was enacted to delimit the Norwegian fisheries zone north of 6628 north latitude. This decree delimiting the territorial sea, we submit that the authorities had used unjustifiable baselines. In fact, it is contrary to the practice of the international law. We sought to show that the Norwegian government has not consistently followed the principle of delimitation, which it claims from its system, and that it has admitted by implication that some other method would be necessary to comply with international law. We would like to state that all sinuosities of the coastline at the low tide should be followed, and that the general practice of selecting the low tide mark rather than of the high tide for measuring the extent of the territorial sea. Hence, we would like to submit to this honourable court that the maritime limits which Norway is entitled to enforce as against the United Kingdom should be drawn in accordance with the following principle that is accepted under the rule of international law. That Norway is entitled to a belt of territorial waters of fixed breadth which cannot exceed 4 sea miles from some point on the baseline, and the baseline must be low water mark on permanently dry land or the proper closing line. As such, my lady, we submit that the lines prescribed by the Royal Decree 1935 as the baselines for the delimitation of the fisheries zone have not been drawn in accordance with the applicable rules of international law on the ground that the decree on the delimitation of the territorial sea was made from an unjustifiable baseline, which is inconsistent with the applicable rule under international law. My lady, having finished with the first issue, Having finished with the issue, does this honourable court need any further clarification before my co-counsel continue to submit further?
No, please proceed.
Thank you, my lady.
My lady, may I begin?
Yes.
Much obliged. Good morning, my lady. May it please this honorable court, my name is IHSAN bin Muhammad KHAIRI, appearing as the junior counsel on behalf of the applicant. Uh, the United Kingdom of Great Britain and Northern Ireland. Having finished with the first issue submitted by my co-counsel, I will now move on to the submission of the suggestion for the limitation method of fishery zone that are consistent with international law. My lady, may I proceed with my submission?
Yes, please proceed.
My lady, there are three methods to apply the delimitation of the fishery zone. The simplest one would be appear to be the method of tracé parallel, which consists of drawing the outer limit of the belt of territorial water by following the coast in all its curve. This method may be applied without difficulty to an ordinary coast, which is not too broken. The second one is the straight baseline method. This method select a perfect point on the low water mark and draw straight line between them. However, my lady, in the current case, we venture to suggest that Norway may draw straight line only across bay and not to draw them between island, islet, rocks, and such area which do not fall within the conception of the bay. The third method is Kobe Tangi or out of circle method, which is a new technique in so far as it is a method for delimiting the territorial sea. This method was proposed by the United States delegation at the 1930 Codification Conference of International Law. My lady, we believe that this method of circle is the correct one for delimiting the territorial sea. My lady, to conclude, we submit that the Royal Decree 1955 as the baseline for delimitation of the fisheries zone of Norway have not been drawn in accordance with the applicable rule of international law, and therefore we venture to suggest that to the court to declare the principle of international law in defining baseline, and if an agreement is reached on that principle, we would suggest its application to Norway. Having finished with the explanation, does this honorable court must need further clarification?
No.
Much obliged, my lady. If this honorable court favor no further assistance, that shall conclude my submission of the remaining explanation. Therefore, thank you, my lady, for your time and indulgence.
Now we proceed with the senior counsel on behalf of the respondent.
My lady, may I begin?
Yes, please.
Much obliged. Good morning, my lady. May it please this honorable court, my name is ZAHRATUL HANAN, appearing as the senior counsel on behalf of our client, Norway government. Appearing together with me today is my land co-counsel, Mr. ALIF AMMAR. My lady, we wish to put forward a single argument. I will be dealing with my argument, and the remaining submission will be dealt with by my co-counsel. My lady, there is a single issue to be submitted before this honorable court, whether the lines prescribed by the Royal Decree 1935 as the baselines for the delimitation of the fishery zone of Norway have been drawn in accordance with the applicable rules of international law. My lady, I will be submitting on the argument and my co-counsel will be submitting on the remaining argument. If there is no further question needed by the bench, may I proceed with the argument?
Yes, please.
Much obliged. My lady, for this issue, we submit that the lines prescribed by the Royal Decree 1935 as the baselines for the delimitation of the fisheries zone of Norway have been drawn in accordance with the applicable rules of international law. My lady, in order to prove that the delimitation of the fisheries zone fixed by the Norwegian Royal Decree of 12 July 1935 is not contrary to international law. On the first ground, we submit that the Norwegian Royal Decree of 12 July 1935 concerning the delimitation of the Norwegian fishery zone sets out in the preamble the considerations on which its provisions are based. In this connection refers to well-established national titles of right, the geographical conditions prevailing on the Norwegian coast, the safeguard of the vital interests of the inhabitants of the northernmost parts of the country. It further relies on the Royal Decrees of 22nd February 1812, 15th October 1896, 5th January 1881, and 9th September 1889. The decree provides that lines of delimitation towards the high sea of Norwegian fishery zone as regards that part of Norway which is situated northward of 66 degree 28 A. North latitude shall run parallel with straight baselines drawn between fixed points on the mainland on island or rocks, starting from the final point of the boundary line of the realm in the easternmost part of the Varangerfort and going as far as Trina in the country of Northland. An appended schedule indicates the fixed points between which the baselines are drawn. Other than that, we do not deny that there exist rules of international law to which this delimitation must conform. It contends that the propositions formulated by the United Kingdom government in its conclusion do not possess the character attributed to us by this government. It further relies on our system of delimitation, which it asserts to be in every aspect in conformity with the requirements of international law. My lady, the second ground under this argument is we submit that the scope of which extends beyond purely geographical factors, which is that of certain economic interests peculiar to a region, the reality and importance of which are clearly evidenced by a long usage. We put forward that 1935 decree as the application of a traditional system of delimitation, a system which we claim to be in complete conformity with international law. The Norwegian government does not rely upon history to justify exceptional rights to claim areas of seas which the general law would deny. It invokes history together with other factors to justify the way in which it applies the general law. These rules of international law take into account to the diversity of facts and therefore concede that the drawing of baselines must be adapted to the special conditions obtaining in different regions, so that the system of delimitation applied in 1935 is a system characterized by the use of straight lines does not infringe the general law. It is an adaptation rendered necessary by local conditions. Additionally, on the question of the existence of Norwegian system, the Royal Decree of 22nd February 1812 is of cardinal importance. This decree is in the following terms, which is we wish to lay down as a rule that in all cases when there is a question of determining the limit of our territorial sovereignty at sea, that limit shall be reckoned at the distance of one ordinary sea league from the island or islet farthest from the mainland, not covered by the sea, of which all proper authorities shall be informed by rescript. This text does not clearly indicate how the baselines between the island or islet farthest from the mainland were to be drawn. However, it may be noted that it was in this way that the 1812 decree was invariably construed in Norway in the course of the 19th and 20th centuries. The decree of 16th October 1896 was relating to the delimitation of Sandmoor. This decree revealing as to the traditional Norwegian conception and the Norwegian construction of the decree 1812. It was by reference to the 1812 decree and specifically relying upon the conception adopted by the decree that the Ministry of the Interior justified the drawing of a straight line 26 miles in length between the two outermost points of the Skagate. The decree of 9 September 1889 relating to the delimitation of Romsdal and Northmoor were applied. The same method drawing for straight lines, respectively 14.7 miles, 7 miles, 23.6 miles and 11.6 miles in length. The 1812 decree was similarly construed by the Territorial Waters Boundary Commission. The Norwegian government had stated that the direction laid down by this decree should be interpreted in the sense that the starting point for calculating the breadth of the territorial waters should be a line drawn along the Skagate between the furthest rocks and where there is no Skagate between the etching points. Therefore, this conception accords with the geographical characteristics of the Norwegian coast and is not contrary to the principles of international law. My lady, the last ground for my submission concerning the argument, we submit that the 1812 decree, quite general in its terms, had as its immediate object the fixing of the limit applicable for the purposes of maritime neutrality. However, Norwegian government found that to delimit its fisheries zone, it regarded that decree as laying down principles to be applied for purposes other than neutrality. The delimitation effected in 1896 and 1889 1896, 69 and 1889 constituted a recent application of a definite system applicable to the whole of the Norwegian coastline and was not merely legislation of local interest called for by any special requirements. My ministry assumes that the general rule mentioned above, which is the 4-mile rule, which is recognized by international law for determination of the extent of a country's territorial waters, must be applied here in such a way that the sea area inside a line drawn parallel to a straight line between the two outermost islands or rocks not covered by the sea. Svinoy to the south and Storholmen to the north, and one geographical league northwest of the straight line should be considered Norwegian maritime territory. If I may refer to the decree of 16 October relating to the delimitation of Sandmore, to justify this, the Ministry for Foreign Affairs of Norway has dealing with the point of view of international law. He said that the distance between the islet of Svinoy and Storholmen is more than 10 sea miles. The fishery limit between these 2 points should have been a broken line following the configuration of the coastline and nearer to it than the present limit. In spite of the adoption in some treaties of the quite arbitrary distance of 10 sea miles, this distance will not appear to have acquired the force of an international law. Still less will it appear to have any foundation in reality when made by reason of the varying formations of the coast and seabed may have an entirely different character from that of another bay of the same width. It seems rather that local conditions and considerations of what is practicable and equitable should be decisive in specific cases. The configuration of our coast is no way resembles that of the coast of other European countries, and that fact alone makes the adoption of any absolute rule of universal application impossible in this case. All these reasons militate in favor of the line laid down by the decree of 16 October, a broken line conforming closely to the indentations of the coastline between Svinoy and Storholmen will have resulted in a boundary so involved and so indistinct that it would have been impossible to exercise any supervision. As such, my lady, we submit that the lines prescribed by the Royal Decree 1935 as the baselines for the delimitation of the fisheries zone of Norway have been drawn in accordance with the applicable rules of international law, since the decree we have referred and the legal conception regarded by the Norwegian government is compatible with international law. My lady, having finished with my part, does this honorable court need any further clarification before my co-counsel continue to submit on the next argument?
No.
Much obliged. If there is no further assistance favored by this honorable court, that shall conclude my submission on the issue. Thank you, my lady, for your time and indulgence.
My lady, may I begin?
Yes.
Much obliged. Good morning, my lady. May it please this honorable court. My name is Muhammad Alifama, appearing as the General Counsel on behalf of the respondent. My lady, having finished with this first issue submitted by my co-counsel, I will now move on to the second issue, which is the limit of the fishery zone has been fixed, was consistent and legal. In this issue, I will divide my submission into two parts, which are: first, there is no opposition encountered in applying Norwegian system by the United Kingdom for more than 60 years, and secondly, straight baseline shall be used to indicate the fixed baseline. My lady, if there is no further question needed by the bench, may I proceed with the submission?
Yes, please proceed.
Much obliged. My lady, for the second issue, we submit that the limit of the fishery zone was consistent and legal. On the first ground, we submit in the court that there is no opposition encountered by the United Kingdom in applying Norwegian system for more than 60 years. We submit that the Norwegian authorities applied their system of delimitation consistently and uninterruptedly from 1869 until the time when the dispute arose. Norway has been able to assert without dispute that neither the enactment of her delimitation decrees in 1869 and 1889 nor the implementation of those decrees resulted in any opposition from foreign state. The general toleration of foreign state with regard to the Norwegian practice is unchallenged back. For a period of more than 60 years, the United Kingdom government itself in no way contested it. It will appear that it was only in its memorandum of July 27, 1933, that the United Kingdom made a formal and definite protest on this point. As a coastal state, with a strong interest in its fisheries, and as a maritime power with a traditional commitment to the law of the sea and the defense of freedom of the seas, the United Kingdom could not have been unaware of the 1869 decree, which prompted a request for clarification from the French government. Being aware of it, the United Kingdom could not have misunderstood the significance of its provisions, which clearly established as a representation of a system. This observation is even more applicable to the 1889 decree on the delimitation of Romsdal and Northmore, which must have been seen by the UK as a reiteration of Norway's practice. Other than that Norway's use of straight line along its coast was a result of its unique geography and has been established through long-standing practice. The United Kingdom and other nations' lack of objections shows that this method indeed shall be considered in accordance with international law. Melody, my last ground under this issue is we submit that the straight baseline shall be used to indicate the fixed baseline. The schedule appended to the decree of July 12, 1935 indicates the fixed points between which the straight baseline are drawn. We submit that this line were the result of a careful study initiated by the Norwegian authorities as far back as 1911. The baseline recommended by the Foreign Affairs Committee of the Storting for the limitation of the fishery zone and adopted and made public for the first time by the decree of July 12, 1935, and are the same as those which the so-called Territorial Waters Boundary Commission successively appointed in 1911 and 1912, had drawn in 1912 for Finnmark and in 1913 for Nordland and Troms. We further submit that 1911 and 1912 commissions advocated this line and in so doing constantly referred, as the 1955 decree itself did, to the traditional system of delimitation adopted by earlier acts and more particularly by decree of 1812, 1869, and 1889. The United Kingdom government and the Norwegian government have a disagreement about the delimitation of territorial water in two specific areas, which are Sverholt Havet and also the Lopp Havet. The United Kingdom government argues that the baseline measurement used by the Norwegian government do not align with the principle established by the court. The United Kingdom denies the characterization of Sverholt Havet as a bay, while the Norwegian government believes the basin should be evaluated based on all geographical factors. The dispute will be decided by the court. We submit to the court to decide that Sverholt Havet has the character of a bay. The United Kingdom has criticized the limitation of the Lopp Havet basin, but we submit that the deviation between the baseline and the land formation is not too pronounced and does not distort the general direction of the Norwegian coast. The Norwegian government has relied on an historic title, the exclusive privilege to fish and hunt whales granted to Lieutenant Commander Erich Lodge in the 17th century to support the claim to the waters of Lopp Havet. The ancient concessions support Norway's argument that the fishing zone before 1812 was larger than the one defined in 1935 and included all fishing banks visible from the land. The United Kingdom recognizes the principle of vision as the delimitation method used at the time. We consider that the historical data produced by the Norway lends weight to the idea of survival of traditional rights over fishing grounds in the 1935 delimitation, especially in the case of Lopp Havet. These rights, based on the population's need and action usage, may be taken into account when determining the limitation line, which is very moderate and reasonable. My lady, we submit that the limit of the fishery zone was consistent and legal. My lady, having finished with the second issue, does this honorable court need any further clarification?
No.
Much obliged. If there is no further assistance favored by this honorable court, that shall conclude my submission on the remaining issue. Thank you, my lady, for your time and indulgence.
So now we proceed with the judgment. The court composed as the argument presented by the counsels will deliver the following judgment. Regards on the issue in this case, the court will first specify the subject of the dispute, which is whether the lines laid down by the Decree 1935 for the purpose of delimiting the Norwegian fishery zone have or have not been drawn in accordance with international law. Based on the submission by the applicant before the court, the applicant denies that the respondent had been drawn in accordance with international law, and it relies on principles which it regards as applicable to the present case. Meanwhile, the respondent, not denying that the rules do exist, contends that those put forward by the United Kingdom are not applicable, and it further relies on its own system of delimitation, which it asserts to be in every respect in conformity with international law. Therefore, the court will first examine the applicability of the principles put forward by the United Kingdom, then the Norwegian system, and finally the conformity of that system with international law. The first rule set forward by the United Kingdom states that the low water mark must serve as the baseline. In fact, States generally follow this criterion in their practices. The parties concur on this criterion, but they disagree on how to apply it. The above described geographic facts compel the rejection of the requirement that the baseline constantly follow low water mark and necessarily result in the finding that the relevant line is the Shagat rather than the mainland. Only a geometric construction can be used to determine the baseline. The United Kingdom government acknowledges that Norway is allowed to claim as internal seas or forge and sand waters that fall within the definition of a bay under international law, regardless of whether the closing line of the indentation is longer than or less than 10 sea miles. The United Kingdom government, however, only accepts this based on historic title. Hence, it must be assumed that they are still of the opinion that the 10-mile rule should be recognized as a rule of international law. Although some states have adopted the 10-mile rule for the closing lines of bays, others have selected a different length. As a result, neither bays nor the waters separating the island of an archipelago have the 10-mile rule as a general rule of international law. Furthermore, the 10-mile rule is also inapplicable against Norway because they have consistently opposed its applicability to the Norwegian shore. As a result, the court determines that the Decree 1935, the limitation is not illegal under international law, restricting itself to the United Kingdom's conclusions. However, as it affects nations other than the one on the coast, the delineation of marine regions has always had an international component and cannot thus be based solely on the wishes of the latter. The following standard can serve as advice to the courts in this regard because they are a result of some fundamental factors inherent in the nature of the territorial sea. Furthermore, Norway puts forward the Decree 1935 as the application of a traditional system of delimitation in accordance with the international law. In its view, international law takes into account the diversity of facts and concedes that the delimitation must be adapted to the special conditions obtaining in the different regions. The courts note that Norwegian decree of 1812 as well as a number of subsequent texts shows that the method of straight lines imposed by geography has been established in the Norwegian system and consolidated by a constant and sufficiently long practice. The application of the system encountered no opposition from other states. Even the United Kingdom did not contest it for many years. It was only in 1933 that the United Kingdom made a formal and definite protest. And yet, concerned with maritime questions, it could not have been ignorant of the reiterated manifestation of Norwegian practice, which was so well known. The general toleration of the international community, therefore, shows that the Norwegian system was not regarded as a contrary to international law. Having examined the sectors thus criticized, the judgment concludes that the lines drawn are justified. For these reasons, the judgment concludes that the method employed by the Decree of 1935 is not contrary to international law and that the baseline fixed by the decree are not contrary to international law either. In one single judgment, the court rejecting all the submissions to the court to the contrary to adjudge and declare that the delimitation of the fishery zones fixed by the Norwegian Royal Decree of July 12, 1935 is not contrary to international law. Court is dismissed.